All right, welcome back. We are looking at item 6.8, our 11 a.m. item, public hearing, consideration of appeal AB 23-03 of Planning Commission's decision to revoke major use permit UP 19-15 for Legendary Farms LLC at 2290 Soda Bay Road, Lakeport, which is located at APN 008-010-09. So first and foremost, we're going to be doing an oath for all those that wish to provide testimony, both online and in the chamber, as well as staff. Then we will commence with a presentation from community development, and then go ahead and open up for arguments from the appellants to be made. I'd like to try and be not brief in meaning 3 minutes, but let's try not to go for a very long amount of time. But I want to make sure you have the chance to provide your arguments on both sides. I just wanted to kind of set the tone for what we anticipate to have. We did dwindle this down, so this is solely about the revocation of the use permit today in front of us. So let's go ahead and get started with the oath. Again, please raise your hand if you are in the Zoom room, which I see none, and all of those in the audience, please raise your hand if you will be providing testimony.
All right. With your right hand raised, do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay. I just have a stupid question. I'm going to embarrass myself with this. Their representative, their attorney does not need to do an oath?
Lisa Stark, no.
Was that?
No.
Okay.
Mr. Chairman.
Thank you. Better to ask than not to know. All right, let's go ahead and get started. As I stated, CDD's presentation.
Good morning. Morning. Mireya Turner, Community Development Director. Before you today is a portion of an appeal, AB 23-03, focusing on the Planning Commission's decision. Yeah, that's the wrong one.
And it's showing on Zoom.
This portion of AB 23-03 is focusing solely on the Planning Commission's decision to revoke major use permit UP 19-15 for Legendary Farms. Nope, that's the other one. Maybe up there at the top left. There are two labeled Legendary Farms. That's it. Yeah, thank you. Awesome. We're just going to get that up and running. Legendary Farms is located on 2290 Soda Bay Road in Lakeport. Awesome. Thank you very much.
And everything's working on Zoom, so you can, I don't know why it didn't before, but we're good.
Just as a quick recap to bring us to where we are today, on September 28th, 2023, the Planning Commission unanimously approved revocation of major use permit UP 19-15. They also determined a number of persons as responsible persons for high severity violations. When the appeal of both those actions came before you, on August 27th of this year, due to the lack of proper noticing for some of the responsible persons, which is a different noticing process in Chapter 13 than what we usually do for revocations, which is in our zoning ordinance, where we follow the government code notifying folks by mail and property owners within 725 square feet of the project parcel. This was a different one, and so out of an abundance of caution, I did switch the recommendation at that time that the board uphold the appeals that were limited to deeming responsible persons responsible for high severity violations. Effectively, we removed the high severity violation from what is going on today, or what is before you today. Since the focus of today's item is on revocation, I will refer to Article 60 in Chapter 21 of our zoning code, and I did provide paper copies for the board, CAO, County Council, press, and there are extra copies on the dais. I already did during the break. These should be at all your spots. This is an overview or an aerial view of the Legendary Farm site. It's approximately, one parcel is approximately 41.25 acres, virtually flat, as you can see on the left-hand side, which has the slope layer applied on our GIS system. You can see that pretty much the only slope is the creek that's on the west-hand side. If you look to the picture at the right-hand side, you will see the approved cannabis cultivation site, which is up to 1 acre, one type 3, in the low to middle part of that parcel, and the non-permitted cannabis cultivation site located at the other end of the parcel. It's approximately 700 and some odd feet, maybe 800. So to put that in perspective, if we were to step outside the board chambers right now and look down the hill, it would be the distance between where we are and maybe Library Park, that far away. Also, please note the two white rectangular structures at the bottom or southeast part of the parcel. These are two unpermitted 5,000 square foot metal buildings that will be covered at a future point or a future slide.
Is that 5,000 square foot each?
Each.
Yeah.
This parcel, as the community knows, has also been used as the Rancho de la Fuente Event Center, and a good chunk of that flat land has historically been used for hay production. And I'm not taking that call. Another point of interest on this particular parcel, it is located within the Farmland Protection Zone. And according to Ordinance 3103, it needs to transfer to mixed light cultivation no later than May 21st, 2023. No permits have been issued as of this date for any greenhouses. This is the Legendary Farm site plan that was approved by the Planning Commission. Again, it shows that 1 acre of outdoor canopy. Processing to take place in the barn that was formerly used for the Rancho de la Fuente events. The yellow rectangle on the southeast part of the site plan was identified an ag barn. On the right-hand side, again, just for reference, you'll see the approved canopy right where it should be. 2 buildings, not where the site plan says they will be. And also later on, we'll see that they were also not used as ag-exempt structures. And then again, at the northeast corner, it was around 3,300 unpermitted cannabis plants getting cultivated in a very similar manner to the approved cannabis plants. The Planning Division of Community Development performs annual compliance monitoring site visits for all of our cannabis permittees, except for the ones who either opt out, or not actually the ones who opt out, in which case if they're outdoor cultivation, we can just take a look on satellite, and if they are not outdoor cannabis cultivation, we actually still do a drive-by or find out and just take a look. On September 12th, 2022, staff did perform an annual compliance monitoring site visit. There were planning and code enforcement staff present, and they met permittee Melissa Smith and her agent Michael Wegner on site. These are just some of the pictures entering the site, the method of cultivation underneath the hoop houses, and the metric tags. The metric tags are something that we're always looking for to make sure that these are licensed by the state of California. And they were present in the permitted cultivation site. When staff arrived on this date, they noticed a second fenced area approximately 800 feet away from the approved cannabis cultivation area. They requested access to that second area. At that time, the permittee, Melissa Smith, left the group. Mr. Wegner escorted the team to that area where they found approximately 3,300 additional plants in cultivation. These photos are just to show similarities in the layout of the pots, but we also did find similarities in the types of strains used, as well as the handwriting on the tags and other markings in the area. On the previous date, or on that date of the initial site visit, staff also requested access to the two large 5,000 square foot metal buildings, but they were denied access at that time. So the next day, code enforcement and law enforcement staff returned to the site, met Mr. Wegner, who actually did the scheduling of that return visit with our staff. That time we delivered a notice of violation and a notice of nuisance in order to abate. Law enforcement demanded access to those structures, and they were allowed access at that time. A little background on these structures. Our department had received 2 applications for agriculture exempt structures. And according to our code and consistent with the application, the proposed use for an ag structure is to be limited to places where your chickens can be in it, storage of farming implements and supplies, so grains, things like that. And in the applications, there were 2, one submitted by Frank Perez, the previous owner of the property, the second submitted by Melissa Smith. The uses proposed were the storage of hay, walnuts, and tractors. The first permit for the ag exempt structure was approved, but it was to be located over closer towards the barn or the approved cultivation area. The second one was in process but not issued. So neither permits were approved for the buildings in their current location, nor were they to be a part of the major use permit 19-15 for the cannabis operations. Additionally, ag exempt building permits do not include electrical or water. Those can be achieved or secured through a separate permit, a building permit. They are also not meant for places of employment. So that second day, when staff did gain access to these structures, this is what they found. Observed were irrigation systems, oscillating fans mounted to the walls, grow lights mounted to the ceiling, air conditioning unit, propane tank, air exhaust systems, multiple extension cords, dried cannabis vegetative waste on the floor, ropes strung throughout the interior, sticker labels with cannabis strain names, stacks of black and yellow totes, industrial fans, refrigerator, wall-mounted flat screen, a number of hoses. No electrical permits are on record for this, for either of these structures. As staff went around behind the structures, they noted an extension cords connecting the structures and crossing the parcel line to the neighboring property. The next year, we went back on September 27th for another annual compliance monitoring visit. We did so because this case had not been brought to the board or for any sort of revocation, which would stay. No action had been taken, which would have stayed which would have stopped the cannabis operations according to use permit 1915. And so we did perform another annual compliance monitoring visit. It was noted that the outdoor cultivation was continuing, and at this point it became an issue because this property is within the farmland protection zone and should be transitioning over to greenhouses and mixed light.
When was that transition date again? Supposed to
May
occur?
21st,
May 21st.
2023. This site visit took place on September 27th, 2023.
Thank you.
Staff went back into the still unpermitted buildings. One still has the processing cannabis, or the cannabis processing infrastructure still in place. Second one still has all the electrical in place. Again, no building permit for electrical. They went and they noted the false wall that you can see the door to in that picture on the left. Went into that room and still noted electrical. In that second structure, still had the television mounted to the wall on the outside with electrical wiring, and then inside that second room, electrical panels, a large television that was a screen on a shelf, a thermometer still on the wall, cannabis matter still on the floor. Major Use Permit 19-15 was approved for 1 acre of outdoor cultivation, along with a Type 3 self-distribution license permit. The cannabis operation, because it has an approved discretionary permit, is to be operated according to the conditions of approval approved by the Planning Commission. Activity observed by staff that is not in compliance with the conditions of approval was unpermitted cultivation in excess of the approved conditions noted on the parcel. Unpermitted structures used in cannabis operation, not part of the major use permit, and actually used other than the storage of hay, walnuts, and tractors. Unpermitted electrical wiring, and a lack of conversion to the mixed-light greenhouses. The conditions of approval that apply to these findings are A.1, substantial conformance with the site plan, which was shown in an earlier slide. A.3, prior to cultivation, building permits should be secured for all new structures. And A.20, noting the required conversion to greenhouses by May 21st, 2023. Article 60 does allow for revocation of use permits for violations of terms or conditions of the approved permit. It is the recommendation of this department to deny the appeal of the Planning Commission's revocation of the major use permit UP 19-15 for the property located at 2290 Soda Bay, Road, based on those violations that were listed in the previous slide and are listed again here, and to direct staff to prepare findings of fact for board consideration at a future date. That concludes my presentation, except to note also that during the break, I also presented the board as well as county council, press, public, and CAO with an attachment of showing the notice of public hearing for both the Planning Commission and the board, as well as the mailing list to whom it was mailed out to, and the affidavit of publication in the Record B, which is according to our government code that we follow for noticing of all public hearings. That concludes my presentation. I'm happy to take any questions.
All right. Are there any questions before we move on to, the next presentation? Supervisor Green.
Thank you for the presentation. I think the most relevant question here is which ordinance are we proceeding under? Are we having disposed of the responsible parties at the prior hearing? Are we continuing under the notion that we are following the provisions of the ordinance pertaining to high severity violations, or are we having a hearing today for more of a garden variety revocation under Article 60?
Thank you. The board did do away with the high severity violation parts of the project. Today's focus is entirely on the activities taking place on the parcel as it pertains to Article 60 in the zoning ordinance to proceed with a recommendation of revocation.
But that's based on an appeal of the Planning Commission's action, and that entire hearing was conducted on the basis of it being a high-severity violation.
The Planning Commission made their decision based on a very similar presentation to what I just gave you, showing the activities that were noted by staff during both of the annual compliance monitoring visits. The data and the information are still presented to you as they were seen by the Planning Commission. The high severity violation, the deeming of responsible persons, has been separated from that decision as far as the board action. But I'll also defer to County Counsel to give you the legalese version of that.
There are two. Hello. There are two sort of parallel actions that were brought before the Planning Commission and your board. One under Chapter 13 and one under Chapter 21. You have dismissed, your board has dismissed the action for Chapter 13, which was a nuisance violation, and that pertained to the high severity violations and the responsible persons. That has been dismissed. We are now focusing on Chapter 21, which is, as you say, a garden variety revocation. Both of these actions are based on the same set of facts and circumstances, but they are not dependent on each other. And so, but not only that, but the high severity violation Chapter 13 section also does say that it is anticipated to be in conjunction with other actions. So it can be brought at the same time as a revocation. The issue was notice, and that Chapter 13 high severity violation issue has been dealt with by your board. So as you noted, now we're dealing with a revocation under Chapter 21. And there are findings related to that, and they would be based on the facts that staff has presented today.
I'm not going to speak for appellant counsel, but I'm going to note that in their filings and at the Planning Commission and in the prior hearing, they have indicated that staff and counsel have conflated the two procedures. And I think there's some validity to that observation. For example, the Planning Commission hearing, it was all responsible parties all the time, as was noted by one of the commissioners. It cast a wide net, and they didn't really deep dive into who was responsible, who was not. This board disposed of that issue at the first appeal hearing before it. But to the extent any examination was made by the Planning Commission of responsible parties, which aren't even defined in the Article 60, they didn't really spend a lot of time diving into the Chapter 21, and I don't think there was really an adequate presentation on Chapter 21 issues of planning. So before we do a deep dive into a Article 60 under Chapter 21, I guess I'm just skeptical of the assertion that you can pick and choose from the high severity ordinance and then Chapter 21 and a revocation hearing initiated with different criteria. For example, if we were to stick to our guns on the high severity violation, having disposed of the responsible parties, and because there's been no imposition of a fine, there's no administrative penalty to consider under the high severity ordinance, and therefore any appeal is moot because there's nothing to appeal. There's nothing left of the high severity. Mm-hmm. To the extent we are going to have a hearing today for revocation under Chapter 21 and the provisions of Article 60. I don't think we ever got to where we needed to be at the Planning Commission level. And so we're going to hear this de novo, so I guess maybe that's moot. But I just don't know. It seems like we're switching procedural horses midstream, and I see the nodding head, but I get to nod my head too up here. So Explain to me then what the theory of the case is in your presentation, and if you need to supplant that again with some additional information. But how is the appellant, Legendary Farms, considered responsible for the violation here?
So the Chapter 13 nuisance violation we'll call them HSVs, high severity violations, HSVs and responsible persons, and the Chapter 21 permit violations are based on the same set of facts and circumstances. So a violation noted by staff and brought to the deciding body would be presented for both of them. A violation is violations. The Planning Commission need not find that there was a financial penalty or a high-severity violation or a responsible person in order to find that there were violations and that revocation is appropriate under Article 60 and Chapter 21. That is independent from a high-severity violation, Chapter 13. The Chapter 13 high-severity violations have been dismissed. There is no decision for responsible persons on that other than the dismissal. But that is not necessary for a Chapter 21 revocation. A revocation is independent of a nuisance violation. A nuisance violation can be used to support a revocation, but it isn't required. So here, what you're looking at, and what the Planning Commission did look at, and what was rightfully before them, were violations. And the violations could have, and according to staff, did support both a nuisance action and a permit revocation.
What they didn't do at planning was find any one of the three grounds that would justify a revocation, that the permit was obtained by fraud, that one or more of the terms and conditions in the use permit that was granted has been violated, and that the use of the permit is so conducted as to be detrimental to the public health, safety, or welfare, or to be a nuisance. And that's on permittee, not on the various other people that were mentioned during that hearing. So I didn't hear it, and I did go back and watch the thing, and it's not binding on us because we are here de novo, but I didn't hear anything in that hearing that specified which of the terms or conditions of use permit 1915 were violated by appellant.
So I want to just interrupt real quick. I see that Mr. Rogoway is here. I'm going to ask you to sit down. You can counter-argue when it's your turn to do your presentation, but at this moment in time, we're asking questions to CDD. You'll have your chance to speak, and I'll make sure you get the time that you need as well. Thank you.
Okay, so to the question. After the Planning Commission acted, and I didn't hear them make any findings of fact, and I don't know if findings of fact were prepared for the record after that, but what is the specific conduct by appellant that we're talking about here today, that Planning Commission upheld, that appellant did violate something, 1, 2, or 3? What did they violate?
Supervisor Green, that would be numbers 2 and 3.
And which permit conditions of approval did they violate specifically?
I believe it
To
was
not
read
grow
out.
outside of the permitted area, as evidenced by the 3,000-plus plants, or to use the AG buildings for any purposes outside of what they're allowed to do. It's perfectly fine to find that the Planning Commission's hearing was insufficient. Before this board is hearing it all brand new. You are free to hear this evidence for the first time, take it into consideration, and not be bound by the Planning Commission's decision. What the Planning Commission did is rightfully find a revocation. The one thing they did extra was make an extra finding for high-severity violations, and that shouldn't have been in front of them. We corrected that by removing them. But the way a high-severity violation is found is, at the time, they would have been cited for it, and they were. And then they have an appeal process, which would have came straight to you. But they missed the window for that. Now, because we found that the notice wasn't perfect, we walked it back. But otherwise, by the time it would have gotten to you, they had missed that window. They didn't do the 3 things that they needed to do in order to appeal that decision. the high-severity violations would have already been baked in. So the fact that the Planning Commission, a year after the initial search, said that, oh, and these are also high-severity violations, is moot. It's not necessary to anything. They base their revocation decision on the evidence placed before them, on the extra plans, on the conduct.
What evidence?
Excuse me?
You found plants off the licensed premises. What evidence was presented at Planning Commission that appellant was a responsible party for that? And in the absence of that evidence, since we're here de novo, what evidence is staff prepared to present today that would indicate appellant is responsible for the illegal cultivation that occurred off the licensed premises?
Supervisor, the licensed premises is the parcel itself. So the licensed premises is not just the area identified as a cultivation area. The parcel itself is approved for a use. The entire parcel is approved for a use. The APN the parcel identified by the APN is approved for a use. That use is subject to conditions, and part of those conditions are restricting cultivation canopy to a certain area, restricting buildings to a certain area, allowing for certain kinds of plumbing or electrical. But the parcel is the approved area, and people are always responsible for their use on a parcel and their ownership of a parcel, and the owner of a parcel is responsible for the things that occur on their parcel, even if they do in fact have a lessee who is engaging in the activity. It is the owner's responsibility to maintain that property and to make sure that those to whom they lease are not violating the law. However, the penalty here is a revocation of the permit, not a conviction of the property owner. The use was not engaged in correctly as
Legendary is not the property owner.
property owner or the lessee, but the property owner and the lessee are responsible. The person engaging in the use is responsible, but they are not. That's not the issue here, because they are not being held to a nuisance violation. The issue here is whether or not the use approved was engaged in violation of the way it was approved. And if it was not, then that permit would be revoked.
I'll withhold my further comments. I would like to hear from them.
Are there any other comments or questions before we move on? So I do have a couple of questions, and just to, I don't have it in front of me, but I know that I wrote here that there was talk about conditions of approval, 8.1, 8.3, and 8.20. You requested what conditions of approvals. I believe those were the comments that Director Turner identified, the specific items within the conditions of approval that were in violation. So I just wanted to give you that answer, just because I felt we had heard that answer. One of my questions is more along the lines of timelines. You mentioned that there was 2 applications submitted for the ag exempt. One was approved. I tried to re-review, not thinking that I had a date, and I can't find a date. Maybe I missed it. But when was the application submitted for those ag exempt, and when was the one that was approved? And what is the process for that? Do we do an inspection after it's built to make sure it's up to code and up to what was approved on the site? Kind of curious about the timeline.
Sure. I'd be happy to get that. That was included as an attachment in the Planning Commission's packet, so let me just get there.
I apologize if it was there and I just don't have it in memory.
No, not at all. There are a lot of pieces and parts to this project. There's the grant deeds. Hoping I have it.
While she's looking, can you repeat those numbers you just cited to me?
8.1, 8.3, 8.20 is what I have written down, and I believe was concurred with by Director Turner, that those were the identified.
8.
Okay.
County Council, please.
And Mr. Chair, just for further clarification to Supervisor Green's question, I believe it's 8.1, 8.3, A.20, A as in apple.
Oh, gotcha. Thank you for that. I heard 8.
So the first
Fishing in places you couldn't find fish.
and for anybody trying to find it, this is attachment number 7 in the Planning Commission's staff report. The first application for an exempt agricultural building permit was submitted by Frank Perez, dated June 23rd, 2020. We do not perform building inspections because the whole point of it being exempt is that the owner is taking on the responsibility for the integrity of that structure. But as a compromise, that structure is not to be used for habitation, employment, things like that. So we do have an assurance by the property owner that that building will be used only to store stuff, or maybe some chickens or animals. The second application.
And when was that one approved? Because you received it on June 23rd, 2020.
Looks like the signatures all came out on the 23rd, June
So
23rd.
all in 24 hours it was submitted?
They're pretty easy.
Okay.
Yeah, the process is we take a look to confirm that there is commercial agriculture activities on that parcel that is a primary use, and take a look at the items submitted. It also goes to the agricultural commissioner first and then comes to us at CDD. We also do get sign-offs from environmental health to note that the location of the proposed structure will not interfere with any septic or wells. And then building and safety also signs off on it before it gets the planning stamp, which was on June 23rd. The next application, which the legal owner is listed as Melissa Smith for United Investment Ventures, which is also one of the property owners, that was dated April 20th, 2022. And this one, because it was proposing a different location, had a little more notes on the application because this is in a flood zone. And so although it is an exempt structure, we need to make sure that it's going to be built at the height above the flood level to make sure that it's not going to flood every year or impact the movement of water. So this one looks like it took a little more time. It sign off from EH on 426. Ag Commissioner from 421, then DPW and Water Resources because of its location in the flood zone signed off on April 3rd, and Planning Division we signed off on, or no, sorry, that was May 3rd. We signed off and stamped it on May 4th.
Oh, so it was fully approved.
It's approved, but from what staff told me, it was not picked up.
Okay.
And let's see.
But again, both of those buildings are not in the location that were identified as the location that they were supposed to be in, or the uses were not based on the uses that ag exempt affords.
The permit for the second one shows that it would be in that correct location, but it had no electrical to it. The permit was not picked up, and I don't know. I think we tried later to get assurances that it was built above the flood zone. I'm not sure if we ever got that. But additionally, let me find it again. It was for the use of hay, walnuts, and tractors with no electrical.
Okay. And I think my other question was just a clarification, and you already gave that to me for May 21st, 2023, and basically it was no more hoop houses because the transition allowed for the hoop houses, and it had to be in an engineered greenhouse. Is that correct?
That's correct.
And again, no application has been received even to...
No application has been issued. I think we did get that, and I was working on getting the date. So all the staff that's listening to me now, if they could check on the date for that, when that was submitted, or if we have record of it, they'll send that to me shortly, and I'll let you know.
Okay.
Thanks.
Those are all the questions that I had. Any further questions? All right, let's go ahead and move on. Mr. Rogoway.
Thank you, and good morning. I'd like to just kind of start
with how this issue is framed. And evidently, Director Turner, County Councilor, trying to remediate a legal problem insofar as there was the wrong process used in terms of Chapter 13 by going to the Planning Commission. I pointed that out to them. They denied that that was the wrong process that was used for several months. And yesterday, for the first time, Deputy County Counsel Torres admitted over the phone that this was the wrong process that the county used, which is a different argument than insufficient notice, which is what Director Turner has argued here today. The theory postulated by County Council is a novel legal contention that does not exist within the Lake County Code. It does not exist within the California Government Code. I have been provided with no authority to demonstrate any basis for the contention that, as County Counsel Johnson stated, there are two parallel processes. Until today, there has never been the contention by the county that there are two parallel processes. And the board does not have to take my word for it. The board can look at the same document referenced by Director Turner multiple times in her presentation. If you just look to the memorandum that was presented to the Planning Commission dated September 28, 2023. If you look at the subject line of this memorandum, it says, consideration of proposed revocation of major use permit UP 19-15 for Legendary Farms for high severity violations located at 2290 Soda Bay Road, etc. The predicate of the proceedings, starting with the notice of violation, which incidentally was only issued to one of the four appellants, United Investment Ventures. The permittee, whose permit the board is being asked to revoke, was never provided a notice of violation, ever. Sitting here today, there's no notice of violation. Fundamentally, I don't know what we're doing here, because without a notice of violation, there is nothing to take to the Planning Commission. If the Planning Commission is given the hearing that they are not legally authorized to hear, that is what's called ultra vires, which is a Latin term that lawyers use, meaning outside of legal authority, which is what I argued emphatically, as I mentioned a few moments ago, to County Council, and they laughed at me. They pretended like this is no big deal. And at the first time that we were here, and there was this last minute continuance of the hearing, the reason for that continuance was because I had confronted them with this legal authority. They were not willing to admit that the authority was accurate. They made up an excuse, frankly, to tell the board as to why we needed to have that continuance. And throughout the course of the proceedings, when it comes before the board, the commentary from Director Turner and from Deputy County Counsel Johnson is one of obfuscation, of trying to make things look even muddier than mud, so that it's so confusing that perhaps just go ahead and deny the appeal, revoke the permit, and see what happens. However, as I mentioned a few minutes ago, at the very beginning of this process, only one notice of violation was served. That was to United Investment Ventures. That was for violations of Chapter 13, not for violations of Chapter 21. Today, you're going to hear me talk a lot about notice. And notice is something that is not just a word that lawyers use to make arguments. Notice is something of constitutional significance. It is a part of the Due Process Clause of the United States Constitution. It is fundamental to the right of every American to have notice of what they're being accused of, to have notice of the process that they will go through for a violation, and they'll have notice of exactly what the violation is and what the consequences of that violation are, and what's going to happen to them. What are their rights? What's the procedure? Can they examine witnesses? Can they present evidence? Is it a fulsome hearing, or is it 3 minutes of public comment in front of the Planning Commission and perhaps 10 minutes in front of the board? Standing here today before the board, I have no idea what process is controlling this, what ordinance we are operating under, what the rules are, what the board is allowed to do and not allowed to do. It's de novo, yes, but this is an appeal from the Planning Commission. The Planning Commission was unlawfully constituted. Their decision is void. We're appealing a decision that was determined to be legally void. And after that appeal was granted, I believe unanimously, by the board, a new legal theory emerged from County Council, which is, for the first time today, I didn't hear this yesterday in my call with them, the first time today is that this is a parallel proceeding, that there are two proceedings happening at the same time, contemporaneously. That is false. It's not the truth. It's not legally accurate in terms of what can happen. Factually, there is no basis for that position. If you go back to the notices, there's nothing in any of the notices that says this is going to be a parallel dual-tracked proceeding, where at the same time, there are going to be two statutory regimes that are going to control. Both are going to be active in terms of what the county is going to seek to prosecute and ask first the Planning Commission and now the board to consider. When brought before the Planning Commission, looking back at this document that I just pointed the board to, there is nothing in this memorandum to the Planning Commission from a year ago that indicates that this is going to be a dual-track, separate process. And it's not just the subject line. It is throughout the entire document. If you go through the entire document, please draw your attention to page 11 of this memorandum. Page 11 of this memorandum entitled Basis for Revocation Request. All cap letters, bold type, underlined. Basis for revocation request. What does it say right underneath that? High severity violation. The basis for the revocation request, according to Director Turner, 1 year ago, was solely for a high severity violation. That was the stated and sole position from CDD, from County Council, until today. To the point of Supervisor Green, this is the same thing I was thinking about as I was on my drive up here, which is that they're changing horses midstream. That's literally the expression in my mind as I was thinking about how to articulate this to the board today. One of the things that is challenging, of the many things that are challenging about this matter, is the duration of time that has elapsed from the violation to today. As we just learned, as I have known for quite some time actually, the inspection first occurred 2 years ago, in 2022. At that time, immediately following the inspection, I provided County Council Torres, Director Turner, with a declaration that was notarized, signed under penalty of perjury by an individual named Robert Luis Tirado. Mr. Tirado is the tenant who rented the greenhouses, hoop houses, on the property, predating appellant's occupancy and ownership of that property. And there, Mr. Tirado stated unequivocally that the cultivation was his and his alone, that Mr. Smith and Mrs. Smith had nothing to do with it. They didn't know about it. He provided his phone number for the county officials to call him to verify that. And I provided that to County Council and Director Turner in October of 2022. I heard nothing back from them for a year. We thought that they were not going to proceed until we received the notice of hearing before the Planning Commission a year later, which is the hearing that you've heard about today. And at that hearing, Director Turner omitted the existence of the Toronto Declaration entirely, as if it did not exist. And this is material evidence that is important for the Planning Commission and for the board to consider. You determine the credibility of it, you determine the veracity, you determine the relevance, of course, but it needs to be presented and not ignored. In response to the omission of the Toronto Declaration, I was allotted, again, my 3 minutes of public comment time, 3 minutes in addressing a high severity violation where the only issues that are before the Planning Commission are those of the high severity violation and the penalties associated with it, including a lifetime ban on getting use permits in the county for cannabis, including all of the various monetary penalties, et cetera. And I used that 3 minutes to talk about Mr. Tirado and the fact that the county didn't even call him. And I knew that was true because we heard from Mr. Tirado that nobody called him. Yet, in response to my arguments to the Planning Commission, Director Turner made a series of false statements about the extent to which herself and other county officials attempted to contact Mr. Tirado and went into great detail about attempts to call, about attempts to, I think, even go to the house and email and other things that they tried to do purportedly. I knew that this wasn't the truth when it was stated. Of course, I need evidence and able to substantiate any of the things that I do as an attorney, so I submitted a Public Records Act request to the county. That Public Records Act request took a really long time to process. And when we finally received the response from the county, the response we received was that no records exist of any attempts to contact Mr. Tirado whatsoever. There's no records. And we followed back up with the county. We spoke to Ms. Kennard, and she again confirmed no records exist. And of course, records would exist if calls were placed to the phone number that was in the declaration. This goes to the heart of who's responsible. If you're looking at the substance and the facts and why on the merits of the factual issues alone, aside from all of the legal issues that separately make this completely unviable as a matter to proceed, we have an individual who said this is all his, the appellants have nothing to do with it, and that has not been controverted in any way by the county. No evidence presented, no attempts to present any evidence. In response to my continued, ongoing, emphatic request to look at this matter, to examine the evidence in good faith, I met literally with laughter as recently as yesterday. County Counsel Johnson, County Counsel Torres, Director Turner were laughing at me on the call before they hung up on me. This is your county. This is who is interfacing with attorneys, an attorney for appellants who have been going through this process for 2 years. For 2 years, it's been the wrong process. For 2 years, they've been going through this process where 3 out of 4 of the appellants have had no notice of any violation, where the county has made no attempt to even contact the person who said it's all theirs. Before today, before the last hearing on August 27th, I have had 3 minutes to present the case of appellants to the county. 3 minutes in 2 years. They've been going through this, they've been paying for me, their life has been on hold. The conversation about them not being able to get permits or not attempting to get permits to do the conversion from outdoor into mixed light is a ruse, because they've been going through the notice of violation process the whole time. It's not like they're going to be issued new permits while they're going through revocation proceedings. When that due date came about, that 2023 due date, they've been in the middle of this. What is the expectation of the county? For someone to go and apply for and pay for new permits simultaneously while the county is attempting to revoke those same permits? It's nonsensical. It should not be a basis for a revocation. Going back to the legal issues, I want to highlight, it looks like there's some photographs being passed around.
We'll make sure.
Another copy of that, thank you.
We'll make sure you get a copy.
If the board, thank you. If the board looks at It looks like, so what I'm being provided is a notice of nuisance and abatement handed to Michael Wagner. So that, just for the record, I don't know the relevance to that at the moment. But going back to this memorandum, we don't have to just stop at page 11. Let's go next to page 12. Page 12 goes through what Director Turner is asking the Planning Commission to do. Find responsible persons pursuant to section 47Q of chapter 13. And so there's the section related to that. The next section is revocation of permits. And so on page 12, we have the revocation of permits where we had the basis being, again, for high severity violation. And then going to page 13, we have the recommendation. The recommendation, if you look at underneath the heading, recommendation, Community Development Director Turner recommends the Planning Commission take the following actions. Revoke major use permit UP 19-15 for Legendary Farms, including deeming responsible persons permit E, Legendary Farms, Melissa Smith, property owner, United Investment Ventures LLC, Justin Smith, former Legendary Farms agent Michael Wagner, adjacent property owner Roberto Estrada, and joint tenants Carl and Lilani Colrus, located at 2290 Soda Bay Road, APN 008-010-29 for high severity violations with the following findings. There's nothing in here about a separate process, about a chapter 21 anything. It's only high severity violations. Then if you look further down, the sample motion for the revocation, the motion from Director Turner to revoke the permit, contrary to what was just asserted to you, which was false, obviously, look here. I move that the Planning Commission revoke major use permit 19-15 for Legendary Farms. It goes on to list the parties as I just listed. And at the end of the paragraph, for high severity violations based on the findings listed in the staff memorandum dated September 28th, 2023. It's unequivocal. This is the record. This is what was being asked of the Planning Commission and what the Planning Commission did. They adopted the sample motion. This was a motion that was adopted. This is a motion that appellants appealed. This is the motion before the board. It is unequivocal. Whatever is being argued to the board now with respect to this dual process, this parallel process, is a sham. It's not the truth. It was not true at the time. It was not true for the next year. This was never raised to me, either formally or informally, here or over the phone or via email. In fact, County Council and Director Turner won't respond to me. For the most part, my emails, my letters, formal correspondence on law firm letterhead go unresponded to because they don't know how to respond, is my assumption. That took them a while to figure out what their story is. How are they going to argue to the board that this is still viable? They didn't have anything to argue to me. They had no legal authority that they could cite to me because it doesn't exist. So they cooked something up and presented it here today. You don't have to take my word for it. Look at the record. Look at what we see on page 13 with respect to the chapter 13 issues. And then today, for the first time, without any notice, again, no notice of violation for 3 out of the 4 appellants. The one appellant who has notice of violation is for chapter 13. No notice of today's hearing. I understand that that was just presented at the break. I raised this to County Council and Director Turner yesterday. They said that you don't need it. Apparently you do because they present it to you, but not me. When I asked them what the basis is of the notice of the chapter 21 violation, because no one has any notice of violation for any chapter 21 anything. They said you don't need it. And I said, why? And Deputy County Counsel Torres said, because people know what they did wrong, and that's your notice. As a matter of law, that is legally inadequate. That is not how it works. If the government accuses somebody of doing something wrong, the government doesn't get to say, you know what you did wrong. That's enough. That's not how any of it works. Imagine being accused of a crime. And you're asking the government, what is the crime that I committed? What did I do wrong? And they said, you know what you did. You're in trouble. We're going to the penalty phase. Is that America? Is that Lake County? It is according to Director Turner and is according to Deputy County Counsel Johnson, but it's not the law. I'm hopeful that the process for this revocation proceeding concludes today with a granting of the appeal. If the county wants to proceed with a Chapter 21 violation, they should find the appropriate way to do so. They should go see if they can have a new notice violation. They can bring that through the appropriate channels. If they can have that go through a lawful mechanism, and then we can respond to that as needed. But this proceeding can't be salvaged. This proceeding can't be remediated by now claiming at this late stage, after so many opportunities to have done the right thing and followed the law, they can't now claim that this is just a parallel proceeding, that it doesn't matter what is in the notice, it doesn't matter what happened to the Planning Commission, it doesn't matter what was asked for by Director Turner, it doesn't matter what is in the memorandum, it doesn't matter what was in the resolution, it doesn't matter what they did, it doesn't matter what we appealed, it doesn't matter what's before you, it just matters what they said. It matters what they're telling you now. That cannot be acceptable to the board. That cannot be what Lake County stands for, and something so serious that changes people's lives fundamentally, that impacts them economically, that deprives them of a property right. It's what is known as deliberate indifference. Deliberate indifference for the deprivation of a property right. That's the analysis that goes to court. Decide for yourselves whether the county is in a strong position with the deliberate indifference and the deprivation of a property right. As we're looking at being asked to, the board being asked to revoke an entitlement, to revoke a major use permit based on the violation that the county now admits they can't proceed with, and now are claiming it doesn't matter because they can just make something up. My request first, respectfully, is for the board to grant the appeal to UP 19-15. That is my request. In the alternative, if the board will not do that, the board has within its discretion under Chapter 60 the ability to modify the use permit. That's not my first request. I'm not asking for that, but I'm pointing out to the board that there is the capability to modify the use permit rather than to revoke it. I think that there is no legal basis whatsoever for the board to revoke the use permit. The record is clear. This has only ever been about a high severity violation. The county did not notice the appellants, 3 out of 4 of them at all, of any violation. They noticed one of the violation that has been essentially dismissed. And that's my request. Thank you for your time.
Thank you very much. Do we have any questions for Mr. Rogoway or comments? Supervisor Green?
To the original point that the Planning Commission's action was taken ultra vires a year ago. You're here today asking for granting of the appeal, even though the decision a year ago presumably was outside their jurisdiction, extending that argument, even if we wanted to grant the appeal, and I can't think where the board's heads are at, we may lack jurisdiction to conduct the hearing today. So,
Agreed.
In the event the hearing does not proceed today, where would that leave the case, in your view?
So thank you for the question. I concur that there is a jurisdictional issue, and there's a contradiction here. I think that's what the issue is that there is an agreement by the county that the Planning Commission was hearing this matter outside of any legal authority to do so. So once that determination has essentially been stipulated, then there shouldn't be anything to appeal. It should essentially just be moot. that there would be no revocation, because essentially the revocation, the determination to revoke the use permit was unlawful, and that it therefore was never revoked. That's what the legal remedy would be. If the board were to essentially adjourn without making a determination, I think what would happen as a matter of law is that unless a party were to renew some type of motion, or to bring it to court, or to file another type of administrative appeal, as long as there was the finding that the initial revocation is void by the Planning Commission, then I think there's nothing left to do here. That's my opinion. But I do believe, just to clarify, I do believe that there is a fundamental legal problem involved with just having the hearing today. I'm not waiving that objection by being here. I just want to make sure that there isn't like a default or something that's entered by my non-presence, because I told County Council, as I mentioned, and Director Turner, that we've received no notice to the things that we're required to have notice for in order for this to be a valid hearing, and that was followed by laughter.
Any other questions or comments? Staff?
Oh, yes. Looking at the penalty section in Chapter 13, you'll see that it's 13.5. There is no part of it that deals with revocation. For revocation to happen, it has to happen under a different chapter, under the chapters dealing with revocation. So to say that it is all tied to 13, that it all has to be 13, just has never made sense. We've expressed that. He has to know that. He's read it. Look at the initial notice, and it says for revocation. That was always a different chapter. The findings for high severity violations go specifically to the people, to the persons. And we're not doing that. We're not asking for that. We took a step back from that. Legendary Farms has gotten every bit of due process that anybody could possibly get. The whole purpose of notice is so people understand what they're being either charged with or asked to fix, and that they have time to prepare themselves. They've had 2 years. They've been here since the beginning. Everybody has known. To be accused of obfuscation in this situation is kind of laughable, because during this whole presentation, the one thing you did not hear was anything about the actual conduct of why we're here. Not once did you hear anything about the 3,000 plus plants, the uses of the AG buildings, none of that. All that we've been hearing is a word salad trying to accuse everybody here at this table, except Johanna, of lying, of deliberately trying to dilute the arguments.
And so if you don't mind, I'm going to take your comment and make sure that we do focus on the issues at hand rather than some of the other interactions that have occurred, because I think we have facts in front of us of what is happening. I do want to follow up, and I apologize for that. I just want to make sure that we're not heating up the room about how interactions went or didn't went, and that we really focus on the matter at hand here. We have some unpermitted buildings. We had an illegal grow. We have a potential revocation in front of us, and we need to make sure that we recognize what is the right process for us to follow, and make sure that we move forward and not side to side. So I do have some questions. One, there's only one notice of violation that I'm aware of. And that notice of violation was done on September 14th, 2022, and it was done to United Investment Ventures, which I believe, please correct me if I'm wrong, because if you want to talk about obfuscation, it's all of the LLCs in different buckets that make it really confusing. But that is the owner of the property is United Investment Ventures. Am I correct on that?
I'm sorry? Who is the owner of?
United Investment Ventures is the owner of the property?
No, I don't.
Yes, the United Investment Ventures is the sole property owner.
Okay.
And this is something, just one clarification.
Chair, who are you asking? Are you asking
So-
staff, or are you asking Mr.?
I will direct questions better. I apologize. Staff, please provide the information on who in United Investment Ventures is that received the notice of violation.
The notice of violation, as you can see in the photos, was handed to Michael Wagner, who was then operating as agent for Legendary Farms. I can double check to see who's written on it, but the pictures that you see.
And I'm just going to go back to the
As far as
question.
property owners, if I could just finish.
Please.
your sentence. It is included in the staff report before you on page 3. In the beginning, the property was owned by Frank Perez, but in subsequent grant deeds transferring ownership of the property, it's gone back and forth to Justin and Melissa Smith as joint tenants, to United Investment Ventures LLC, to Justin and Melissa Smith, and then Justin Rabin Smith and Melissa Pat Smith as co-trustees of the Justin and Melissa Smith Living Trust. Most recently, the grant deed that I could find on July 11th, 2024, there were 2. So the one that was recorded second was transferring it from United Investment Ventures LLC to the Justin Rabin Smith and Melissa Pat Smith co-trustees of the Justin and Melissa Smith Living Trust, UA dated 10/31/10/23. It's my understanding that that is the current entity that owns the property.
And I'm looking for who was the current during the NOV, because we can't just update based on who is the current owner. Who was the current owner during the NOV?
So on that table, then, the Planning Commission, okay, so go back. So that would be the time of the site visit, which was in 2022. In that time, in 2022 until 2023, United Investment Ventures LLC was the grantee of that latest grant deed. So that was the property owner.
Okay. And so to me, that makes sense that they would receive the NOV because it was not within the premises of the permit, it was within the property itself, and you're dealing with the property owner to deal with these violations.
And our normal procedure would have been to hand that to the agent of the permittee, as well as follow up with certified mail to the property owner as well.
And so I see here the code violations that are written on the NOV all relate to Chapter 13. One of them is lack of permitted, just lack of permits. I think it's a general lack of permit statement for Chapter 13, Article 1, Section 13-31E16. And then Chapter 13, Article 7, 50.3 is what points to the high severity violations. That doesn't mean that the whole entire thing is just, it's an addition to the lack of permits. There's the addition of the high severity violations. It's not just that solely. And so I want to highlight that. It does say underneath, but it's not stated in the code violations of Lake County Code Chapter 21, because the permittee within Chapter 21, which would be the commercial cannabis cultivation, they themselves did not have a violation of their permit. It was a violation within the parcel, which then violated the conditions of approval. Am I correct on that?
I would actually dispute that because
Please do.
Cannabis activity that's not part of the major use permit that takes place in 2 unpermitted structures with unpermitted electrical, I would plant solely within the responsibility of the permittee. Additionally, it does state our conditions that when we do go to inspect, we don't limit it to just the approved little canopy area. We're looking at the parcel because we want to make sure that all activities are in accordance with the approved use permit.
And I'm glad you brought that up. I have it right here. I was able to go back to at least September 28th, 2023 for the Planning Commission, where it says here in section L2, and it's the first bullet after the first paragraph, the project parcel shall be inspected by the Community Development Department on an annual basis and or less frequently if approved by the Community Development Director. And the inspection is to find any and all potential issues that would be in not in accordance with the conditions of approval.
Indeed, and it is beneficial to our department to do so, to take the entire parcel into regard, because what we are finding in a couple other of future revocation recommendations is an agreement or is an understanding between the property owner, permittee, et cetera, and the people who are cultivating for their permitted cannabis. It's an acknowledgement that in order to get paid, you can go grow over there. You take care of my stuff over here, and you can go grow over there, and the money will be shared.
Objection.
And so I don't know that that's what is happening here. We don't have any evidence to show that that's what's happening. I'm just stating actually one of the main benefits of the fact that our conditions of approval do take into account the entire project parcel.
Two points, supervisors, and I apologize if I'm confusing or if I speak too fast. Please let me know, and I'll slow down or I'll clarify what I've said. Earlier, when I said that there were two parallel processes, I was trying to make clear the fact that there are two code sections that apply in this circumstance, and I apologize if it caused confusion. Chapter 13, as you've noted, Chair, is related to violations for nuisance violations, right, that are related to the individuals. And that is the chapter that requires a notice of violation. So it would not cite Chapter 21 because it relates to the process of Chapter 13 and notice of violations, that an individual who would be penalized under that code, that ordinance section, would be given an opportunity to correct them and not receive per day violations or some other kind of penalty under Chapter 13. Today, we're not asking you to look to the notice of violation for penalizing the individuals who acted in this circumstance. We are asking you to look at the Chapter 1 process, Chapter 21, process that relates to a revocation. And a revocation can be based on noted violations, even if there was not a notice of violation, and even if there was not a finding of high severity violations, because that Chapter 13 process relates to the individuals and penalizing the individuals. Chapter 21 has its own notice process, and that's Article 57, and it is notice for a hearing. And the individuals who are noticed, it's a wide breadth. There is a posted in the newspaper of general circulation. There is posted to neighbors and property owners within a certain 100-foot range. It's a broad notice process. And that would be a notice that there is a consideration of revocation based on noted violations of the permit that applies to that property. And staff not only looks to beyond the cultivation area because they have noted that there may be violations in many circumstances beyond that approved cultivation area, but they look beyond it because your ordinance applies uses to the entire lot. And in the case of cannabis cultivation, your ordinance has a limitation for square footage based on certain other criteria, and it applies to the entire parcel. So they would look at the entire parcel because the conditions apply to the entire parcel. If it is limited to 65,000 square feet of canopy, for example, there cannot be any other canopy on that lot because the lot is permitted 65,000 square feet of canopy. So that's just one example of why you would look at the entire lot. But notice here, the individual's individual notice of violation would not need to be would not apply to the Chapter 21 hearing because it is in relation to the Chapter 13 violations for the individuals. And we have already noted that the individuals to whom those violation penalties would apply were not properly noticed, and therefore we are not asking that Chapter 13 violations be pursued against those individuals. However, the notice requirements for Chapter 21 have been met I think your board was provided paperwork earlier that showed the posting in the newspaper, the addresses to whom the notice was provided, a declaration as far as posting in the newspaper, so that any interested party would have had proper notice for the revocation, that staff was recommending a revocation based on the notation of violations. And while they may have defined them in their first staff report to the Planning Commission as high-severity violations, the fact that an individual or set of individuals had not been found guilty or at least been responsible for those high-severity violations does not mean that those high-severity violations did not exist. And the fact that they existed or may have, or that staff is claiming or asserting that they existed, is support for a revocation action. And if any of that was confusing, I can certainly explain.
We started from a bad place, so thank you for trying to help us to get to a better place. In reading, and I'm about to muddy it a little bit more. The violations are what brought us to Chapter 21 for the revocations, because you can't get to Chapter 21 just because you feel like going through a revocation process. There has to be violations or conditions of approvals that are not being met and consistently not being met, or something along the lines.
The violations that staff is asserting for the revocation are violations of the permit conditions. A use was permitted on this lot. That use had criteria that had to be followed in the form of conditions of approval. Staff in their inspection had determined that those conditions were not followed. Regardless of whether or not an individual person had been found responsible for those conditions, they were not followed.
And so when this is not the first conditions of approvals that have not been met or have been violated, what kind of noticing occurs upon a condition of approval found not to be met? Is there a notice of violation? Is there, what occurs at that point?
In general, as we have encountered them the last couple of
Because
years.
if there's a code violation, I expect that the next step is a notice of violation. And if there's a condition of approval that's not met, what is the next step on that? Is there some official documentation that's provided to the individual?
Yes.
Or to the permittee?
After the inspection, the permittee will receive the inspection report. We come back to the office, finish out filling out the report. Typically, the planners will consult me if there's some issues, and we decide, okay, are we going to just work with this? Let's let the property owner know. Can we are these simple ones, like a building permit for this?
Or a lock on a gate?
Our goal is to not bring everything to you for revocation. It's only the more egregious ones. And so if we can meet with the property owner to get it fixed easily, we're not following up with code. If we meet resistance, we're going to get the code out there for the actual paperwork to start on a notice of violation, and the citations will start.
And so this applicant received a report of the inspection with where they did not meet the conditions of approval, with expectations of what needed to occur in order to meet conditions of approval, or what was that situation?
We did have discussions with them regarding the issues. However, I did not think that this was one that could just be quickly fixed. It had unpermitted structures where unpermitted activity was taking place. It had 3,000 plants in a totally disconnected portion of the parcel. So it wasn't like whoops, I'm, exceeding my square footage or something like that. It was an obvious, purposeful cultivation of unpermitted plants. And so to me, this wasn't, let's just get it back into, let's just fix it. So I let them know, this is going to go to the Planning Commission. And as I tell all the people who ask that question, this is going to go to the Planning Commission, so you'll have your opportunity to present your side. So, because it's not me, I just make the recommendation in compliance with Article 60.12 to bring it to the Planning Commission with a recommendation of revocation. And so that is what I did.
And so, again, just to make clear, documents were submitted to the applicant to let them know that they weren't meeting conditions of approval, or was it just verbal?
That part would have been verbal.
Okay.
I think we did send a notice, a letter just saying that it was going to come, but I'd have to actually check my records because I'm not 100% positive about that one. But we did have ongoing discussions.
And in the notice of violations, again, I'm going back to that, it says remove all cannabis plants, but it doesn't mention anything about the buildings at this point in time in the notice of violation itself. I also saw pictures in September 2023 of plants being grown, obviously way beyond the May 21st, 2023, but I don't see a notice of violation. Was a notice of violation provided at that point in time?
I do not think so. And also, thank you for that, because I need the opportunity to correct what I told you. I told the board that building permits had been submitted for greenhouses. That's not accurate. A planning application for the conversion to FPC with building plans were submitted. No building permit application has been submitted at this time.
For the conversion to mixed
For the
light?
greenhouses, correct.
Okay. I feel on a personal level that we're getting, what's the right thing to say? I don't know if it's a misuse of the expression, but I feel like somebody's thumbing their nose at us. You have a violation, you put in more plants in September 2023, you still have your buildings up that obviously were used for not good activities that would be permitted for. If it was used for hay in the wrong location, I think that's a different situation, but obviously with all of the gearing up for indoor, like that's not good stuff, but I have to, I'm hurting myself here that I'm not sure that we noticed appropriately, and I'd like to get a better understanding, because United Investment was the property owner, and if we didn't provide any documentation to the applicant saying, here's your issues, and the notice of violation never mentioned the buildings, there's never a new notice of violation mentioning the new pot grows in September 2023, I feel that I'm saying yes to undocumented things that verbally is not, in my opinion, enough to be able to move forward. What's happening is not appropriate as far as the activity on that property, and I have to make sure and say that. But I'm also not quite comfortable with what I have in front of me unless you can present some better evidence or reason as to why, because I feel like we need to say today, you have 30 days to get rid of those buildings and so on and so forth, and start that process over for revocation. But right here, all I see is United Investment, not Legendary, and no notice of violation for the other things, just the plants that happen to be gone, from what I understand, fairly quickly after we told them to get rid of it.
Yeah, I understand your concern, Supervisor. I think that the issue here is confusing notice to the individual for a penalty that would be applied to that individual, and notice about the misuse of a property. So in the case of a revocation, put aside the notice of violation, because that is Chapter 13, and we're not addressing Chapter 13 today because we are not handling notice of violations for a nuisance violation. You are not going to be applying penalties for anything under that ordinance section. What we are asking today is for your consideration of the application of Chapter 21 for a permit revocation. A permit is issued after analysis, giving approval of a lot's use under the ordinance that your board has adopted. There is a permitted use, in this case it's a cannabis cultivation, and that use, after analysis and review, is restricted by certain conditions of approval. Those conditions of approval are the notice of how this property is to be appropriately used. Anyone who uses that property, regardless of who it may be, has to follow the permitted use of that property. It is their obligation to make sure that the way they're using the property is accurate and correct. If it is not used appropriately, if there is no permit, they don't get a permit. If there is a permit and they don't take the steps to learn what the appropriate use that is allowed under that permit may be, then that property is being inappropriately used under Chapter 21 as per the use permit approved, which means that it doesn't matter who used the property inappropriately. Because we're not determining responsible persons, we're just determining whether or not that permit was followed as approved. And if your board can determine, based on the evidence provided by staff, that there were violations of this permit, then a revocation is appropriate. The notice applied under Chapter 21 for a revocation is, as I said, under Article 57. And Article 57 has various ways in which notice is to be achieved, including notice by publication, notice mailed to a number of neighbors in the vicinity, as well as the property itself. Anybody in use of the property should have had notice. They could come to the county and check the permits for permitted uses. The conditions of approval are the notice for what is appropriate use of that property for that particular kind of use. When you have nuisance violation under Chapter 13, it is very different. It's associated to the individual. You have to identify the appropriate individual because they will be individually penalized. Usually it's finances. That is not what we're asking here. We're asking Chapter 21 revocation. Staff has noted in their inspection that the permitted use for this property has been engaged in incorrectly in violation of the use permit. And because of that reason, they have brought it to the Planning Commission and now your board asking for a revocation because the conditions were violated. And notice, as I said, is in Article 57, and that notice was provided. Not only that, but the parties here who are opposing the revocation have been at every hearing. They have filed numerous PRA requests with the county. They have provided numerous filing documents, or essentially, for lack of a better word, letters, like the one you received today, the thick packet. They have had every opportunity. They have had every opportunity to comment. They have spoken at both the Planning Commission and before your board. So notice was not ineffective here for this revocation.
Additionally, in our records, we do have the ag exempt building permit application, which the applicant was Melissa Smith for United Investment Ventures. So I'm not sure where we could have been informed that United Investment Ventures would not have included the permittee, Melissa Smith, who's Legendary Farms. So when we presented the notices to the agent at that time at the site visit, the permittee had already excused herself and was not there. But we have paperwork in our records that connects her. It's signed by her on behalf of United Investment Ventures. So I'm not sure how we would have known that it would not have reached in our outreach, in our mailings and notification procedure that anyone would have been excluded.
I don't disagree. However, that's the unfortunate nature of the inbred LLC situation that we're dealing with, where there's 5 names on 5 different LLCs. And I really, again, I feel like these people are laughing at us by growing even in September 2023 or still having these buildings up. But at the same time, I'm looking for a storyline that I'm not seeing documented that makes me feel comfortable. You can have the same name in 5 different companies, that's good, but if it's one company and one name, I feel we don't have the documentation to show that it was submitted properly. And this is the unfortunate situation of what we're dealing with, because
All I have are my report to the board, or my testimony that we did have ongoing conversations regarding those structures.
yeah.
Ms. Smith was well aware that the structures were problematic for a very long period of time, and it has not been resolved.
But I also don't see a notice of violation for that, and that's a problem for me.
A notice of violation would not be required for a permit violation, because there is already notice of a permit.
No, because that would be on, but I'm going to stop talking. The property is not acting appropriately, and I would love to see moving forward with what's being requested here, but I am stuck at this moment that the property owner did not receive a violation of a building, but yet we're using that building to do something like a revocation. If everything was right here, then I would say it's been documented, we've taken step by step, but I can't help but feel like if I'm auditing this, that I'm seeing pieces of the story missing in documentation.
Right. Well, under Chapter 21, there is not a requirement for a notice of violation. That is a Chapter 13 process. And in relation to nuisance violations. And nuisance violations, in that Chapter 13 section, there is language that states that any violation that is not already covered by a permit would be subject to that particular code section. So the violations related to a permit are addressed in Chapter 21, and the permit itself is notice of what is required, what actions are required, and by default, anything outside of those actions would be a violation. So the person engaging in those activities is either not looking up the permit, which means that they are not concerned with knowing what they can legally do as for that particular use on that property, or they don't care that they are acting outside of that permit condition requirements. If you are taking an action on a property, you have to ask the county. You have to ask the county, is this permissible, and what permits do I need for this to be allowed? If you don't do that, you are acting outside of, you're acting in violation of the ordinance, and that would be an unpermitted action. It would be a Chapter 13 nuisance violation. If you are getting a permit and you look that permit up because it's already attached to the land and you bought it for that reason, or you are applying for one, you will know at the issuance of that permit what you are allowed to do. So if you are acting outside of that, you will already know you are in violation. So the issue here, so Chapter 21 does not require a notice of violation. Chapter 21 requires notice for a hearing, which would give the property itself notice. So it would be posted, it would be mailed to the last known address for contact for that particular property. Oftentimes, I think it includes the person who pays the taxes, and I think community development, although Director Turner can speak to this more, also includes the last known address of permittees and other people involved in the process of gaining the permit if they have that, and it also includes neighbors. So what it does not require in Chapter 21 for a revocation is a notice of violation, because that is not what's at issue here. What's at issue here is that a permit is being violated. The person acting under the permit has the obligation to understand what actions they're allowed to do. If they're not acting within that, they are in violation of the permit, and staff can bring a request that permit be revoked because there are violations. Staff has brought a number of violations to your board. They don't include just the buildings. They also include extra plants and other kinds of things like electricity and plumbing and a number of things that you saw in the presentation. So your board hears this de novo. The staff has presented violations that they have noted, and they have asked that a revocation under Chapter 21 be approved. So I'm not sure
Excuse me,
where
Chair.
the disconnect is.
One second, Nicole. Chair Sabanti, I think what you're looking for, it's not going to be called a notice of violation. It does take the form of the notice of hearing. For Chapter 21 revocations, that's the notice they receive. And it's noted on there that they'll receive a staff report at least 72 hours before said hearing, listing everything that's going to be presented there. So that's how, if they somehow did not know what they would be going up on revocation for, they would have access to the staff report listing out everything. And that's what serves as the notice. Outside of that, nothing else is required in our Chapter 21.
I'm going to be quiet right now and let other board members speak and ask questions if there are any. Supervisor Green?
Thank you. In the interest of time, and so we don't have to come back here, I do think one approach, I do think if we were to proceed at all today, I think granting the appeal in full would be the only lawful path. I'm concerned, to be honest, about some of the statements made by staff, not in any snarky, like we're being mean, but if the premises and the parcel are being equated here under the county ordinance, that's very different than what state law does. One reason state licensing does distinguish premises from parcels is because of the never-ending string of LLCs. It gets hard to assign responsibility when you have, in this case, a 40-acre plus parcel with not one but two use permits on it and other types of activities going on. The assertion here is that the permit holder here either caused the violations or should have known somehow, even though there's no evidence before us that the permittee had control and custody over the rest of the parcel. Even if they had noticed it, they have no legal authority necessarily to proceed, and I don't see anything baked in the use permit that creates an affirmative obligation for them to police other parts of the parcel. That said, I hear in comments from my colleagues in the skepticism rightfully expressed by staff, these were serious violations that occurred. And just as the Planning Commission expressed frustration with that and really desired to have somebody held accountable for those violations, they couldn't get there. And we may express similar frustration here today. And because of that frustration, I'm a little worried we may take actions that may not be legally supportable, and we'll continue this conversation either at this venue or in the Superior Court for no good reason. I want to notice that because if we were to proceed today in a slightly different tack, I know staff is recommending revocation, but there's also a procedure for modification of a use permit within the same section of the ordinance. I'm concerned about the violations that occurred just as much as everyone else. They are staggering. But the whole reason we do permitting and the whole reason we have nuisance ordinances is not to be punitive. It's to bring properties into compliance. It's to look for ways to bring our permittees into compliance. And unfortunately, they've been fighting this battle so much, they've dropped a couple other balls, including the conversion to mixed light. I don't need an immediate answer, but before we take a vote, and I'm going to suggest maybe we can take a lunch break so y'all can think about it, if you would be open to reviewing proposed language to modify the use permit that would impose additional requirements upon the permittees, including more frequent inspections, including legalization of the unpermitted buildings to the extent possible, and triggers for additional discipline should additional violations be made. My question would be, one, would be staff amenable to even considering such language for modification? And similarly to the appellant, if we want to tighten up the use permit, make sure we hold their feet to the fire on the mixed light conversion, make sure we get 3103 in there for at least the next 2 years while the application for the modification of the use permit is pending, et cetera, et cetera. So I do have a framework in mind that short of a full-blown revocation, but also short of a full-blown granting of the appeal, if we could find that middle ground and find some language that the parties would agree to modify the use permit, that would be the motion I would be interested in making, because I don't want to come back here under a different set of rules. I can't proceed in good faith as presented here today without granting the full appeal, or at least trying to. And I do think some accountability is required here. And I think we have the ability to do that by taking notice of what has happened, taking notice of the complexity of the parties involved and the property involved, acknowledging state licensing and your local permitting process have distinctions between them that have created some confusion here, at least in terms of legal responsibility for the violations. But what can we do to right the horse? And maybe you're not there. Maybe we just can't get there. But that's the offer. I have 5 bullet points that I think would be lovely modifications to the use permit that would definitely enhance accountability, that would create sanctions for further violations, but would also set them firmly on the path to compliance. So I'll leave it at that. That's my kind offer.
Were you planning to respond or make a statement?
I'd be happy to. So this was our first revocation that I've ever seen done, and so I did give it considerable thought. Went back and forth. Is this the right way to proceed? Thinking not just about this particular matter or this issue, but considering it as establishing a pattern for future revocation recommendations. It was due to the significant, purposeful violations of the conditions of approval of what the Planning Commission had originally approved for this operation that caused me to consider the recommendation for revocation as appropriate. That being said, I serve at the pleasure of the board. If it's the will of the board that we find a way to negotiate, I'm not sure what that means for the unpermitted cannabis cultivation or the cannabis activity taking place in those structures, that it wasn't just, oops, we didn't get building permits, it's we're using them for our cannabis permit, though it's not part of our cannabis permit. But if the board would like us to seek resolution with the client, we will do so.
Very much. Vice Chair Crandall.
Yes, and so you just said a statement that I was going to ask a question about, and because I've heard, through all this, and I know you said, just let me know if you were confused, because I'm not. I just want to know if I heard right, because you're mentioning the notice of violation, and then I've heard the conditions of approval be mentioned, that's basically like the roadmap to how you're supposed to move forward. And in being a planning commissioner, I remember going through this process with people that were contesting permits and just continuously getting us through a point. One being the Valley Oaks. I don't know if anyone remembers that one. Finally, we got to a list of conditions of approval, and that was a really extensive, long list. But that was a roadmap as to what they had to do. Not just that, but others as well. And so what I'm hearing is the fact that they didn't basically go by the conditions of approval puts this situation where it's at right now.
That is correct. After the permit is approved by the Planning Commission, the permittee goes over the conditions of approval, and that's your roadmap for operations, along with the property management plan that was cited there and the site plan. They're all cited in the conditions of approval. When you construct 2 buildings without permits, one in a location that was not proposed, so two buildings and neither of them with electrical permits, I think it would be reasonable to assume you would know you were doing so outside of your conditions of approval.
An A7 under this one that you've given me for conditions approval is
Prior to cultivation, all buildings must have building permits. All new buildings should be constructed with permits. That applies to that one directly. The lack of conversion also is in the conditions of approval.
Let's go ahead and open it up for public comment. Anybody who did the oath, you are eligible to come on up. I'm not going to pick which one goes first. Please just come on up to the microphone. And please put your hand down so you can get some blood back down to your arm. We will not ignore you. Yeah, for public comment, we're going to be doing 3 minutes. Please.
Joan Moss. I have puts a bug in your ear that you may be looking at the person that is not responsible for the notice. I believe I know things about Frank Perez that point to him. I know I worked with him with the farmer's market. He is known as a fence.
So I just want to quickly add that
I want to
Frank
meet
Perez
with
is
her
not-
and give her the information that I have.
I do not believe he is on the agenda today for us to discuss, and so I think that
That's why I want to meet with the lawyer. I want to meet with her.
And that
Thank
is
you.
up to her to decide what to do.
He is the unpermitted owner.
I would rather we stay within the context of what's on the agenda.
It is on the agenda. He is involved. He's the original person that had the property. Thank
Okay.
you. I want to be on record before I go to the higher authorities to tell you
We're done.
that you're not looking at the right person.
We're done.
Thank you.
Thank you. Next, please.
I've been coming to these meetings now for 2 years. And one of the main reasons I've been here is because I feel some fault to why this has all happened. And I'd like to explain real quick with a quick thing. I'm 64 years old. I've never been arrested. I've never been in the back of a cop car. I have no criminal record whatsoever. And that can be, I give you permission to look at my record.
Now that you've said that, could we get your name, please?
Frank James Perez.
Thank you.
Okay. I introduced Mr. Torado. I'm probably pronouncing his name wrong. He worked for me, and he told me eventually, and I told this to the planning department, but I didn't get to tell you guys. He told me that he was interested in growing things for the local restaurants around here that we did before. And in that area where he was growing, we were the first permitted in 2015 by this county to grow medical marijuana there. He was never told to grow any kind of marijuana there. He was supposed to be doing the herbs and spices for the restaurants locally. That's what he told me. So I introduced him to the Smiths to get him in there. And he went south. And I think this was a conspiracy because one of the guys that knows the owners here had a disagreement with them and went to Maria and told her a lot of stuff, and this is what's causing this axe to get grinded. Only Maria knows this. I know Maria. I've never had any problems with her. She's a good person and everything, but sometimes when you listen to people, it's not all what it's all about. And I wanted that to be, to let you guys know. And I really mean this. I'm very proud to be 64 years old and have no criminal record whatsoever. Thank you.
Thank you. Next, please.
Michael Wegner. This process has been going on for years now, and one of the things that I think has brought us to today is the Planning Commission hearing all by itself, and especially since Michael actually watched this Planning Commission hearing. They repeatedly said that because there was no responsible party, they had to cast the net broadly and move it forward as it was. Was that your understanding, Mr. Green? Okay, so because there is no responsible party to be found is why they went ahead and pushed all of us, myself included, into the responsible parties and brought us to your board through the action that we wound up going through. Now, with that, the responsible party and the question about the responsible party, when that was brought in front of the commission and the commission asked if that person had been contacted, and the answer is yes. both our department and law enforcement has attempted to contact these people repeatedly. And then when the facts of the matter come out through two separate public information requests, two separate ones, because the first one wasn't enough. They went back and did it again, and they searched everything from personal cell phones to law enforcement to the entirety of the county. And no one had ever once attempted to contact the person who was the responsible party, the person who should have taken the brunt of all of this. The county didn't even attempt. But they were told, the Planning Commission made their ruling based on the fact that those people were told that they had tried to contact him, that he had absconded, and they couldn't find him, couldn't talk to him. They made their entire ruling based on that. And that was absolutely either incorrect or a straight out lie. One of the two. That, to me, is just astounding. Procedure, process, all of that set aside. We've all been working on cannabis for a long time here. The question for me is how much time and resources are we using to take away legal cannabis in this county? How much money are we spending to do that? I don't at all disagree with the board that these were egregious, they were violations, right? That some kind of disciplinary action must happen, and absolutely that should come in the form of monetary, because it's America, right? Money. People get fined. And if you look at the DCC, that's exactly what they do, and the fines increase, right? If somebody's not paying attention, okay, well, first it's 1,000, then it's 20,000, right? Third time, bam, you're out. But it's very clear what those costs and fines are. And ultimately, this is not, in my mind, and I could be wrong, but I think in the best interest of this county to take away legal operators.
Please finish.
Instead, I think that we should, I think we should fine people. And
Please finish.
That's it.
Thank you. And sir, you're not a member of the public. I'll get back to you to make sure that you have your final comments before we entertain what we will be doing. So I want to make sure the public has the ability to speak before I come back. And so anyone else wish to speak from the public? There's no hands in Zoom, no one moving, so I'm going to close the public hearing. And then I do want to come back for final comments from both. I'm going to start with Mr. Rogoway and come back to CDD, and then hopefully we can make a decision here of what it is that we need to do.
Yes, thank you. I had approached the podium essentially to provide a citation to the board with respect to the assertion that there is no notice requirement for the Chapter 21 proceedings. So what I'm looking at is Lake County Code. It's within Chapter 13, 13-3 is within the definitions, 13-3.3.1. And if you look down at subsection 6, violations, this is for nuisances, and it includes in the definition one who violates any condition imposed by a prior discretionary land use approval pursuant to Chapter 21 of the Lake County Code. So within Chapter 13 is included the type of violation that County Council argues is separate from Chapter 13. And further, if you look down at, bear with me again, section 13-6. This section pertains to the notice of nuisance and order to abate, which is what is issued always by the county, as far as I know, for all the matters that I've been involved with, which is many. That's what the county issues when there is a nuisance violation subject to Chapter 21, because of course, if there's going to be a Chapter 21 revocation proceeding, it has to be predicated on something. It has to be predicated on a violation of some sort. The assertion that the conditions of approval alone provide notice of a violation is something I've never heard or contemplated before. It's a specious legal contention that is, I argue, without merit, without authority. If you notice, members of the board, there is no citation, there's no legal authority that's provided. When we hear argument from County Council as to Chapter 21 not containing the notice provision for the violation, well, that's true by omission. because what's being omitted from that is Chapter 21 is addressing the hearing itself. The section that was discussed is the hearing itself. The Chapter 13 is what discusses the nuisance, and that is what would address the violations of the conditions of approval of discretionary use permit, as I just read, anything with respect to the buildings that have been at issue here, also contained within Chapter 13-3, and then 13-6 has the real definition, not just of like that there is a nuisance in order to abate, but 6.1 has the contents and what's supposed to be included in that, and it's substantial language that is there. Looking down at 6.2, the service of notice of nuisance in order to abate. Again, substantial language that goes into that before it gets into hearing procedures. And of course, the photograph that was circulated for all of us is nothing other than that notice of nuisance order abatement being given to Mr. Wegner. So county council's contention is flat wrong, based on nothing, no authority, contradicted by the ordinance, contradicted by their own photograph that they circulated here. So my request, again, just to renew that briefly, is for the board to grant the appeal in its entirety. Secondarily, although not my request, but an option, as has been mentioned by Supervisor Green, is a modification. And I can tell the board that there is nothing controversial about getting the conversion for mixed light, for doing the conversion from outdoor to mixed light. That's not an issue. The issue is that there's been a violation, a revocation proceeding occurring for 2 years. So I don't think that that's going to be a problem. I don't think that these types of concerns are things that the board has discussed, are things that are controversial to appellant. So I think that there is a way to reasonably accommodate the concerns from the board to make sure that there is the character of the property is sufficient for the board's expectations of what is expected here in the county. And that can be accomplished certainly without revoking the use permit, contrary to every single legal authority that there is. Thank you.
Thank you very much. I want to pass it on to CDD for final comments,
Thank you.
or staff, either or.
Chair, I just
Didn't
wanted-
mean to choose who was
No,
speaking.
That's fine. I just wanted to clarify the citations that were just provided. The citations for Chapter 13 apply to nuisances and nuisance violations. And as I've said in the past, the facts can support both a revocation and a nuisance violation. In this case, staff noted a nuisance violation and served a notice for that under Chapter 13. As I said earlier, we are not asking you to act on that. You did in the prior meeting on this issue that we asked that that appeal be approved. The section that was just cited in Chapter 13 states that if upon making a reasonable determination that a nuisance exists, as defined in just Chapter 13, the enforcement officer shall cause a notice of nuisance in order to abate to be served, as defined in Chapter 13. Now, if you move to Chapter 21, for the ordinance that governs when a revocation is brought to your board or the Planning Commission, in the findings, the 3 findings listed that you may find are grounds for a revocation. Number 3, in 60.11A, number 3, it lists that you may also find for a revocation if a nuisance has also been found. So Chapter 21 does not intertwine with Chapter 13 in the way that was presented. A nuisance, if a nuisance is found, if a notice of violation is served under Chapter 13 and a nuisance is found, then that can be used to support an action of revocation under Chapter 21. It is not required that you have the finding of a nuisance against an individual under Chapter 13 to find that there are violations sufficient to support a revocation under Chapter 21.
Just a quick question. I know the answer, but I'm going to ask the question. Are there things in the conditions of approvals that can be violated that are not a nuisance?
It depends on,
such as 4290 compliance or things of the kind?
yes, because there are things that apply to, say, other laws. I think there are conditions and there are parts of the conditions of approval that require the anyone engaging in that a permitted use gain any necessary permissions from other agencies and things like that. A nuisance violation applies only to certain violations of your ordinance. So there are some things in the conditions that would not be.
Right.
Just briefly, I would remind the board that you are hearing this de novo, brand new, to make any decision that you see fit, regardless of what the Planning Commission may have found. If you think they made the wrong call, you can go against them. But if you find that there is enough here to show that this permit should be revoked, then that finding can be made. If there's questions as to whether or not that evidence exists, I'd be more than happy to answer them. But the plants were there, the buildings were there and being misused. And if we wait to see solely direct evidence of maybe seeing the Smiths themselves out there farming the illegal plants, we will never revoke anything because it will almost always be circumstantial evidence. That's the nature of these things. If we allow ourselves to get tied into knots about LLCs and names when we all know the parties involved who have been served, who are the noted owners, we'll never be able to revoke anything and we'll just continually get ran over. I ask that if you do have a question about any of this, look again to the pictures involved. Ask Maria a question, and she'll show you. They were egregious in their actions against the county. This permit should not stand. It should be revoked. If there is a legal reason to go forward, they can, and I'm sure they will, appeal it to the Superior Court, and we'll hear it all over again. But the evidence before you is enough. This permit shouldn't stand.
Dr. Turner?
Thank you. In 2022, code enforcement and planning staff performed a site visit that is just like any of the over 120 site visits they're performing now during the summer months. The inspection started at the beginning of the property where we're checking for 4290 regulations such as Knox boxes and things like that, as well as prominent postings of the state license. They proceeded to observe activities that were clearly not part of the project, such as 3,300 cannabis permits with no tags and not part of the approved canopy area. 2 unpermitted structures. Evidence, these aren't, like if it's just a shed, we're not going to consider that a nuisance. We're going to get a permit or a zoning clearance. But these were 2 5,000 square foot metal structures, as well as evidence of cannabis operations going on in those structures. In 2023, they returned and found other violations, including the lack of conversion to mixed light, which would be in conformance with the Lake County Code and their conditions of approval. On August 27th, this board did separate the responsible persons of high severity violations from the overall appeals and directed staff, that would be me, to come back today focusing on the revocation of the use permit. And that's the presentation that I showed you today, is what staff found on their site visits, the violations that were occurring, and the process through Article 60 through which a revocation is possible. That's all I have for you today. Thank you.
Thank you very much. Vice Chair Crandall.
A last question, actually, just question and then just a discussion about after my question. So with a permit, if a permit is given to a business or whoever, and then that business or whoever sells that land, which I know happens frequently in our county, and a new owner takes over, obtains the land and operates under that permit and breaks it, what happens? Is it the permittee that we gave it to, or is it the new owner?
Thank you. Yeah, use permits follow the land regardless of ownership. And so the approval, the conditions of approval would stand no matter if the property is transferred to a different owner, or whatever, and that does happen. In cannabis-related permits, we just make note of the file that there's a new owner of the permit or a new permittee. That's no big deal. It doesn't impact the environment because the understanding is that those conditions of approval are to be maintained. Should the previous or should the future property owners decide they want to amend, it's the same process as if it did not change ownership. Should the project or should the permittee desire amendments to that project, they come to the Community Development Department and we work with them on that.
Thank you for that. And lastly, I'm just throwing this out there, and it might be something that's not, will be able to be considered for this, but when you look into 49.2 of the ordinance, the most recent ordinance, amount of administrative penalties imposed, were there fines on each plant that were already out, that were found?
We did not assess fines on the plants this time.
I mean, because I just heard something about fines, and I mean, we're talking about 3,000 plants, and 51 or more plants would be 500 per plant, which would equal 1.5 million. I mean, that might be something we consider. I heard that brought up. I'm just throwing that out there.
That is one of the options that is in the code. We did not pursue that with them.
Can we still?
I think the timeline would not lend it.
Just throwing it out there because I know it was brought up, so I'm just thinking
But we
maybe
will
that
keep
might
it
be
in
an
note
option.
for future reference.
Supervisor Simon.
Muddied water, unclear, there's no doubt about that. This is as you said, the first revocation hearing that has at least got in front of us, so about as confusing as can be. But, I'd like to simplify things. 2 questions, well, 3. One, I had one question heard today in the hearing that code enforcement showed up to the property, asked to enter the properties, and were denied. What was the date on that?
That was the first site visit on 2022, where the staff, code enforcement and building staff, requested entry into the 2 5,000 square foot metal buildings and were denied at that time.
And then needed to get a warrant to go back in? How?
The next day, when staff returned with law enforcement and law enforcement requested strongly access to those 2 structures, it was granted at that time.
All right, thank you. I just need to clarify that for myself. I think it comes down to, for me, I will just say, working through the process today, following the use permits that we provide for cannabis, for legal cannabis activity here in Lake County. It's been talked about, it's laid out correctly. What can happen on that property if you get these permits to make sure do it? Not asking anyone to police them, but knowing your environment and what's happening on the parcel is really important to keeping that alive and moving forward for a successful business acumen. I think we have the opportunity. 2 questions. Can we revoke the permit? I think yes. And was notice given? Yes. So for me, I think in the information provided today, I was hoping we'd never get to a point like this, but I'm not going to argue back and forth one way or the other. Violations occurred, plants were found on the property, buildings were found on the property. We have applications saying they were only going to store tractors, hay, and equipment. It's written directly in there and signed, for those permits that were asked for some of those buildings. So I'll wait and see what the rest of the board is going to do with this, but I just ready to move forward today.
Supervisor Green.
Just for clarity, for those attending, County Council is sitting in a different capacity than council sitting at the table on behalf of CDD. I have not heard from County Council. I did share by email some suggestions for modification language. So my first question is, regardless of other statements, is if we are to proceed under this hearing under Chapter 21, is modification a thing? Is it within the discretion of this board to offer a proposed modification of the use permit as opposed to a full-blown revocation?
Yes, as part of your board's discretion, as it relates to this appeal, your board may grant the appeal in part and modify the permit subject to specified conditions that your board may impose.
And having spent some time hatcheting together those ideas, I don't know how useful they would be to pursue based on the continuing assertions by staff and council representing staff that other than the fact the violations occurred on the property, no other showing is needed to determine the responsibility of the holder of the use permit for that activity. And again, I want to distinguish very strongly how state licensing differs from this process. And although they do allow permit revocation of a state license, it's distinguished as a serious violation, and you need to have knowledge and intent. And one reason I think they bake that in there is the constitutionality of taking a serious sanction. A permit revocation is a serious sanction, depriving the appellants of both the use of the property and future income that derives from that. So I can't speak to the wisdom of the state licensing process or how it developed, but I see themes there that are utterly absent from our ordinance. And so the more you stick to your guns on this ordinance and what is required or not required to show before we take sanctions against a permittee, I got to ask myself the question, is the bigger flaw with the appellants or with the ordinance that they're being subject to penalties under? I would like to propose a modification that would, among other things, set a firm deadline for them to submit an application to modify their use permit to mixed light cultivation. Granted, the deadline has come and passed of Ordinance 3103, but also granted, they've been fighting this thing for 2+ years. That would be one bullet point. Assuming they timely present such an application, permittee may conduct state licensed cultivation using hoop houses constructed and operated in full compliance with Ordinance 3103 until such time as the mixed light application is approved or until December 31, 2026, whichever comes first. And that mixed light cultivation shall not commence prior to issuance of the modified county use permit, state mixed light cultivation license, and any other approvals that may be required. That in no event will any unpermitted cannabis cultivation occur on the licensed premises or on any other portions of the property located at 2290 Soda Bay Road in Lakeport, APN 008-010-29, for any personal or commercial use. And any such outdoor cannabis cultivation by any person, regardless of purpose or purported authority, and regardless of the presence of any hoop houses or lack thereof, may thereupon be considered grounds for revocation of use permit 1915 without further notice or hearing. And finally, that any unpermitted building shall be removed or brought into compliance with imposition of treble fees where authorized by the Lake County Code, regardless of the intended use of the buildings by permittee or other parties, and that permittee will expressly acknowledge that ag-exempt buildings constructed for storage shall not be used for commercial cannabis activities. I think that would strengthen things that are already basically stated in the use permit. I think it would put permittee on notice that even if they don't have the ability to police it, that their permit will be at risk if the property owner or other parties engage in unpermitted cannabis cultivation. Absent consideration of the possibility of the modification of the use permit, the only action I see before me is to make a motion to grant the appeal in full.
So at this moment, I just want to pause. I'll come back to you if you truly want to offer that motion so we can look to see if there's a second. I know that Director Turner wanted to speak, but I do want to bring it to Supervisor Pyska because in my opinion, I'm not interested in any adjustments and I don't want to give time if that's the same opinion being shared by the majority of the board in response to that. And so I'm feeling that is the will of the board to not go in that direction at this moment in time. So Supervisor Pyska, please.
Yeah, I have no interest in any modification or negotiation at all. This is our first revocation. It's been a bumpy road. I think there's been a lot learned, but I think it's clear that that is the direction that we need to move. There's been zero effort to come into compliance and make any of these issues right. And this is, we are in a place of setting precedent, and I think there's been a lot of lessons learned here too as we move forward. There was a question asked of how much money we've spent trying to keep these applicants from growing. I think we've put a lot of effort into building this industry and supporting this industry, and to see these, the nose thumbing and the egregiousness of this, that's very disheartening of what we have put forward to make this a viable industry here. So I'm ready to move forward.
Please, Vice Chair Crandall.
Yes. No, I do want to state a couple things. And Mr. Perez, Frank, thank you for coming up and stating what you said about not knowing the gentleman or what he was moving forward with, and you took responsibility for it. Appreciate that. And the statement that Mr. Wegner, you made about charging fines, I really like that idea. It's just too late. And if any attorney would probably say, well, on what basis if we made that decision? And so I know I can't just say, hey, let's do that, because if I were you, the first thing I would do is file a complaint on that aspect. So can't go there now. So the only thing I can think of is to go with what we have before us. And, Supervisor Green, you, myself, I know Mr. Perez, I know Mr. Wegner, we're all a part of developing this ordinance during those timeframes. I remember in those lengthy meetings that we had as Planning Commission, these gentlemen would come up, you would come up and talk about all of these different things and aspects that we would look at when it came to crafting this, right? I just making sure that, we remember that time frame, because it's unfortunate that sometimes these things are new and we have to go through them, but we have what we have before us, and the only thing we can do to correct that is after we deal with this. It's unfortunate, but
Mr. Roy, I'm going to ask you to sit down. We're done with comments from yourself, our staff, and we're just finalizing up here at the Board of Supervisors. I'm thankful for all the comments. It's always difficult to deal with something for the first time. There's a lot of learning moments. I do believe that my personal learning moment that I would like to see is all inspections result in documentation with you have 30 days to comply to this, or it could lead to revocation. That way, that gives us all the documentation we need to fully support 100%. There are notice of violations here that were provided to the landowner at that time. I would like to believe that in the future, we look at and I'm not saying you don't, but I want to make sure that we treat our cannabis industry like any other local business, where we give them the documentation saying, hey, your landowner is messing everything up for you, you're about to lose your permit. To give them that chance to also be a force to help make the change. Granted, in today's situation, the landowner is the permittee with a different business entity, but if there is separation, I want to make sure that there's always going to be that notification, because I think that would be helpful. I don't want to see my business name put out on the newspaper that there's a potential revocation coming in a public hearing. I would have liked to have something in documentation prior to that rather than just to the landowner. And so I know there were conversations, but verbal to me is very different than in documentation, especially with providing documentation to decide how to move forward. So I think, to me, the learning moment is documentation, because it's helpful in these situations. The fact that there's still buildings there, the fact that you planted more pot in September of 2023 after the deadline, the fact that you haven't submitted and now you're claiming you didn't have time because of the revocation. May 21st, 2023 was the deadline to transition. In 2022, probably already too late at that point to submit an application and have it timely so you can get it processed. This process only started as of September 23rd, specifically at this level. But I think already at the time of the inspection, you should have already submitted something. We gave you ample time to be able to transfer and transition and there seemed to be a lack of effort. There seemed to a lack of care about the community around you by continuing to plant more when you're not allowed to. And so today, I again, love to see more documentation in the future. I think we need to have a set way of dealing with all the applicants in the same way of here's your inspection report with the final comments on you're good, or you have 30 days to fix these things, or else this could lead to. I think that would be great. But today, I cannot disallow this revocation when you've been basically kind of laughing at us and laughing at the community around you, just doing your own thing. I apologize that in America, you really have to ask permission for certain things on your property, and you just didn't care to follow the rules and do the right things. And so in this county, we have rules, and if we let this one slide, then we're going to get laughed at for just letting people slide. And I'm not going to do that today. So I think we have learning moments, but I think that today we move forward. And looking for a motion.
Just very briefly before the motion, we are making a record here, so should have known. We're sending a message. Again, there's not a shred of evidence that has been presented here that would make Justin and Melissa Smith responsible for the violations. And I grant the difficulty that this ordinance poses if we would impose that type of requirement. But
and we are not.
There's no substantial evidence, there's no preponderance of evidence, there's just nothing. So other than the fact that we want to hold people, they, accountable, you don't know that they are the proper they. And
This
you
is
don't
not a
know
deemed
that.
responsible situation anymore. This is an issue of conditions of approval that allows for the inspection of properties to ensure that there are no violations, because this is a land use permit, not a person special permit.
Distinction without a difference, so take your motion. But this is going to go somewhere, and I have a sneaking suspicion what's going to happen up there. There is no evidence that Justin or Melissa Smith are responsible for the conduct, and on that basis, there is no rational reason for this board to revoke the use permit.
Thank you for your comment.
Opinion.
Looking for a motion?
Chair.
Please.
So, Mr.
Guantanamo.
Chair, members of the board, so in light of what has transpired since a previous hearing on August 27th, and on the record, there appears to be more than one request for appeal. One that was filed via correspondence of September 1, and one that was received by CDD staff on October 4, both falling under 2023. The one from September of 2023 references the notices of violation, and your board has already made determinations of that, and that's under Chapter 13. So the one, but there's also the notice of appeal that was filed on October 4, 2023. All of that is for purposes of background for your board, so that for purposes of this motion, your board may move for an intended decision granting the appeal in part and denying the appeal in part, and that would correspond to those two. The motion being with this intended decision to grant the appeal in finding no high severity violations under Lake County Code Chapter 13 as to the appellants, and the denial in part of the appeal would consist of the denial of appeal AB 23-03 and revoke major use permit UP 1915 based on the findings that were stated on page 13 of the September 18, 2023 staff report submitted to the Planning Commission. In particular, those are findings 1, 2, 3, and 5, because that's what CDD is relying on, and direct staff to prepare a draft findings of fact and decision. So it would be a granting in part as to the high severity violation appeal, and then it would be a denial in part as to the revocation under appeal, revocation of the major use permit appeal.
And are those two separate motions, or can we do that in one motion?
It can be done in one, and there would be, with the direction of staff as part of your motion, there would be, staff would prepare for draft findings and fact and decision for your board's consideration within that 45-day limit.
I have a question for you. Can we add in there anything regarding the, oh,
Go ahead.
Can we add anything in there regarding the buildings needed to be dealt with within a certain time frame? Because I'm not happy that we're still dealing with something after all this time of interaction.
And mainly because.
And direct staff that within 30 days, these buildings need to be either taken down or brought to code, or certain, what can we do about that?
So that direction can be made separate from
Okay.
your board's motion as it relates to the appeal or appeals. That direction of staff to explore or to look into ways on how to address the building situation can be given by your board by direction.
Okay, because I don't want to forget that there's still current violations as we speak.
I will move the recommended action from county council.
Second?
We have a motion and a second. All in favor? Aye. Any opposed?
No.
Motion carries.
And then directing staff to.
Yes, and that is part of the motion too.
Oh, you said there was a follow-up one for bringing the
Oh, yes.
property into compliance? Is that,
And that can be made by motion or consensus by your board as it relates to the buildings.
The ag exempt buildings, and I'm doing air quotes because they don't seem to be utilized as such. Can we give a time frame? Well, I guess it's up to staff. I don't want to give staff a whole, a small time frame at this moment in time.
I'm in agreement with that direction.
Looks like we have
Yeah.
consensus that staff continue to deal with those buildings and try to get that rectified as soon as possible.
well, with the revocation of the permit, like everything cannabis needs to be removed from property, correct? Like hoop houses, everything.
So the buildings remain unpermitted with unpermitted electrical, and no apparent hay, walnut, or tractor needs. So we would be happy to take a look at where we go from here. There are some implications. I anticipate this will end up in Superior Court, and so I'll consult with County Council to see what options we do have, and then work with the property owners.
Okay, I think you
And
have,
is there a current cannabis crop?
We have not performed an annual site
There's not
monitoring visit
anything
this year.
Nothing grown? No. Okay.
it looks like you have consensus.
Removal of the
At
buildings
this moment, we're
will be our
done. If
last.
you want to speak after the fact, that would be great.
I'm just requesting a transcript.
No.
Removal of the.
You can
the
request that after.
Buildings will be our last option. We'll see how we can get them permitted.
Okay. Thank you very much. Looks like you have consensus to continue that work, and this concludes this item. If the board, and please, if you can sit down, again, you can ask for things after the fact when we're.
It's on the
recess.
record request. I apologize, Supervisor Spatier. My request is to have a transcript
No,
of these
I'm-
proceedings for
I'm-
purposes of the appeal.
That
This
could
is an
have been
appropriate
done when you
request.
had the chance to speak.
This is appropriate to do right now. There's no violation of any ordinance or local rule from me requesting a transcript for purposes of appeal. I'm requesting a transcript. There's a video proceeding. I can request a
that
video.
request done. Thank you.
Okay, when can I have the transcript?
Administrative records, including transcripts, requests can be made through the administrative office, and they can assess fees through that. So.
It would be really nice if you can ask permission to speak rather than just speaking. I mean, it creates a little bit of a bad situation here, and I don't appreciate that. We'll give you what is needed and what is rightfully allowed to give you, absolutely, 100%. But this is just, we're done at this point, so please sit down.
Mr. Chair, CAO.
Please.
Yes, we generally do not do verbatim transcripts if that's what he's requesting. We can provide him the audio and then he can obtain those services, but we only complete action minutes and admin.
And again, staff is available if there are questions.
Videos on Granicus.
And videos on Granicus, YouTube, Facebook, it's in many, many different places. We have one more item that I just want to make sure we can just conclude so we can be done with our meeting rather than going to lunch and coming back for a 5-minute item. And that's item, and I apologize, Director Turner, 5.4. I'll read it slow as we try to get our...
Our chief building official was waiting for my signal, so I just sent that signal. If we could just give him a moment.
Let's go ahead and take a 5-minute break, and then we'll come back. And this should not be longer than 5-10 minutes for this item, I do not believe. Yes, 5 minutes.